I come at this from a slightly jaundiced perspective because nobody ever phones me up with queries unless it's gone horribly wrong, as in like my finding the presentation on here. Sorry. And slideshow. What I was planning to do, if I can find some slides, go, is talk through some of the legal issues that crop up. As I say, I only ever get contacted by people when it goes wrong. Clients rarely phone me up for a chat or to say things have gone well. So my view of shipping operations is entirely negative. It always goes wrong. I always see the worst in everything. I wanted to cover off, therefore, a few things. You know, when it all goes wrong, an example of when it all goes wrong, and I've got two. I've got one written down there. I have another one as well. Neither of which involved the fender suppliers or anything else. These were like vessel issues. I want to cover off tanker charter party terms, what typical tanker charter party terms look like, and the sharing of responsibility or the movement of responsibility between owner and charterer. Typical legal issues that arise when there's an issue, when something does go wrong, and the options available to various people. Now, the initial questions that I usually get are around, do I have to perform this ship-to-ship transfer with this proposed vessel in this location from an owner? My ship has been damaged during the STS operation, who's responsible? And most commonly, and nobody's touched on this at all, cargo-related issues. Do I have to sign a bill of lading for this cargo? There's water in the cargo. The cargo measurements are wrong. What do I put on the bill of lading? Who's responsible for that? Now, from a commercial chartering point of view, and the movement of oil and selling oil around the world, which is, after all, what this is all about, the cargo-related issues are perhaps the most important.
But STS on board doesn't actually deal with cargo.
I've said that it doesn't. It's nothing to do with that. This is between master and charterer. This is a cargo transfer, cargo measurement. It is nothing to do with the fender and the person in overall charge. It's to do with the commercial aspects of operating it, which is what the charter party is about. Let me just talk to you a little bit about the Asian Progress and the Byzantio. It's not a case I was involved with directly. I was asked to look through the expert reports afterwards by one of my colleagues in our Hong Kong office at the time who was preparing for mediation to try and resolve the dispute. Asian Progress, 300,000 ton deadweight, modern VLCC. I think she had a Scandinavian crew on board, so well operated, well run, well put together ship, top quality. The Byzantio was described in the press as being the next Prestige. She'd been hounded around Europe by Greenpeace, had moved over to the Far East, and was engaged by the charterer to undertake a ship-to-ship transfer operation off the Asian Progress. Why? I have no idea. Cutting corners, saving costs, the only available vessel, I don't know. Vetting and quality assurance, just non-existent. Poor pre-transfer communications between the two vessels. Vessels brought together without incident, tied up. The planning of the cargo operation, extremely poor. Miscommunication about rates, which the Byzantio could receive cargo at. A degree of arrogance, possibly, from the crew of the Asian Progress. And what happened was, discharge started, and it started too quickly for the Byzantio's liking. The PV valves on deck started to vent cargo in addition to the gas coming out of the mast riser. Chief officer asked the Asian Progress to slow down the discharge operation. Asian Progress said she did slow down, but there was a dispute about The chief officer, who was inexperienced on board his vessel, decided it would be a good idea to initially just open the PV valves, and then he went one step further and opened the tank hatch lids to allow the vapour to escape from the cargo that was being loaded into his ship. He then took the next step of opening up additional cargo tanks when he already had several almost full, which resulted in a vacuum in some of his cargo tanks and air being drawn into these tanks, so the vapour space became explosive as opposed to inert. For whatever reason, I have no idea, a spark occurred. Somebody was chipping or painting or something was unprotected in the forecastle head, and as a result there was an explosion. 2 crew members died. Both vessels were damaged. And that's sort of the worst case scenario. That's the type of things which we as lawyers get involved with. The issues involved all 3 parties. It involved the charterer. Had he exercised due diligence? Was he responsible under the charter party for any of this? The officers and the crew and the owners of both vessels, which were both damaged, have insurance claims against one another. And invariably what happens is you get lawyers involved who rub their hands with glee, start the clock running, and charge inordinate amounts of money to unravel the problems. So, from a former Shell seafarer's perspective, and having been in this industry for 25 years, getting the quality right at the beginning and getting the process right, and all I've heard today is sort of arguments around and comment and question about people who are essentially passionate about what they do and are keen to see it done properly. You know, which is great for the industry, but equally there are people out there who still cut corners and still get involved in the more the rougher end of the market, if you like. Charter party terms then. Who's responsible for what? I've picked on Shell Voice 6. I'm slightly biased in that sense, but BP Voy is essentially the same. There's a couple of variations between Shell Voy and BP Voy in this sense. That gives the charterers the option to undertake lighterage operations by ship-to-ship transfer. Both contracts define port and or berth as being a location at sea, include a location at sea where ship-to-ship transfer can take place. Both charter parties limit the charterer's liability for safe ports and the nomination of a safe berth or a safe port to one of the exercise of due diligence. So if you fix your ship on a Shell Voy or a BP Voy charter party, the charterer's responsibility when he chooses the port is only to exercise due diligence. So he sends you to a port, and provided he can show that he's exercised due diligence, if your vessel gets damaged at that port, the charterer can hold up his hands and say, that's not our fault contractually. Now that extends to ship-to-ship transfer operations because that falls within the definition of port and safe port. So here, under Shell Voy or under BP Voy, the charterer's responsibility is limited to one of the exercise of due diligence. Now that would be due diligence in the choice of vessel, transshipping vessel, the vessel that's going to be brought alongside, and due diligence in the context of the engagement of whichever service provider is chosen to bring the act as the intervening party, to bring the fenders and everything else, their experience. There's a requirement that ship-to-ship operations will be undertaken in accordance with IFSTS, OCIM for ship-to-ship transfer guide, but still subject to the due diligence obligation. A safe port is defined in law. It's a case called the Eastern City. It's basically one that a ship can get to, use, depart from without exceptional standards of navigation. So provided the master acts reasonably, undertakes the operation, then the port is defined as being safe. The due diligence obligation waters that down somewhat, because the charter is no longer undertaking that, you know, if there is an undetectable obstruction on the seabed, the charter is not saying, I will accept responsibility for that. He's saying, as long as I've undertaken reasonable checks, I'm off the hook. Typically, when there is an STS operation and there is an incident as a result of it, you look at the actions of both vessels. How were they brought together? I've seen argument from lawyers that the collision regulations should apply. I've always thought that to be nonsensical. I mean, you're quite deliberately bringing the vessels together, and the collision regulations bear no real part of it. Although, I did deal with one STS operation off West Africa. It was an OSG vessel, brand new, maiden voyage, first cargo. She was destined to discharge by STS. The owner expressed concerns about the quality of the other vessel that had been chartered. She was a sort of 1970s vessel. She came alongside and overshot. But rather than going round, she decided it would be a good idea to come astern and try and manoeuvre herself into position astern first. So the master on this lightening vessel then collided with the bow of the OSG vessel, causing not a huge amount of damage, but, you know, given it was a brand new ship straight out of the builder's yard and was in pristine condition, understandably the owner was a little bit aggrieved about it. That's the type of thing which typically lands on my desk. Charter parties which don't have a lightening provision in them. Charter parties like Asbertank Voy, which are more sort of bare bones charter parties, typically have a raft of additional clauses attached to them. A typical Intertanko have produced a ship-to-ship transfer clause, an STS clause. It's very wide-ranging and places all of the liability on the charterer. Charter almost indemnifies the ship owner for undertaking the chartering operation, and is therefore in marked contrast to what you have from BP Voy or Shell Voy. So I think from I'll speak from an owner's perspective, but equally this applies to a charter or whatever. I think the parties to the operation need to have exercised due diligence. Under a Shell Voy, the charterer needs to exercise due diligence. Quite often they will inquire of the ship owner if they're happy with this vessel. The inquiry of the ship owner in itself doesn't relieve the charterer of their obligation. They still have to undertake inquiries, make the necessary checks in order to demonstrate that they've acted diligently. So, due diligence is nothing more than acting reasonably. Ask yourself, what would a reasonable charterer do in these circumstances? What inquiries should you make of the location, of the quality of service of the other lightening vessel, and of the people you're engaging to provide the additional services? When the STS is actually in place, clear lines of communication. If the vessels come into contact, who's responsible? That's an evidential issue. Cargo measurement, issue of bill of lading, and I'll touch on those topics. Shell Voy. What inquiry should a reasonable charterer make? Now, there's no hard and fast rules on this. I mean, the concept of DYNAMARINE providing additional information in the industry seems to me, as a lawyer, something which would be a good idea. Equally, engaging competent and reputable service providers, vetting those service providers if appropriate, long-term contracts with minimum service providers where you have a track history with them, all seem positive and sensible steps. When you get an issue, when you have a dispute, For those of you who've never been engaged in the litigation process, a lot of it is just about balancing. So you present your evidence, but equally your lawyers from the other side will present competing evidence and challenge yours. And essentially all you're trying to persuade is a judge or an arbitrator that you're more right than they are. It's a 50-50 choice. Essentially, you want to get to 51% in terms of persuasion, and the evidence will be challenged. I have an example of communications between parties, which I always drag up at this time. And just clarity of communication, which is important. One of the things to always ask yourself is, would I like somebody to read this in 5 years' time in open court and have to explain myself? You know, is the English good? Does it make sense? Can it be misinterpreted? By way of example, my wife texted me. I was at a conference. I was about to speak. I was jet lagged. I'd flown, I think, to Singapore. I got a text message from my wife to ask whether or not I was going to be home in time for dinner about 3 days' time. So would I be back when I flew home? Would I arrive home in time to have dinner and go out with some friends of ours? And for some reason she had it in her mind that I couldn't really be bothered going out with two of her friends. And mistakenly I replied, sure. Just sure. I was busy, I was jet lagged, I was tired. I replied, sure. I didn't put a kiss on the end of it. I didn't say that would be great, but you know, I was keen. I thought it would be a nice evening out. I'd have arrived home, slept on the plane, I would be out for dinner. Sure. My phone was glowing red by the time I had finished talking. I had that many missed messages and text messages from my wife expressing dismay at my brevity. And when I phoned her up and said, no, actually, no, I was really looking forward to it. What do you mean you've cancelled it? She was like, well, you just said sure. So be careful in what you put. Be careful in how you communicate, because it comes back to haunt you at a later date. Delegation of obligation. A ship owner cannot delegate his obligation as to seaworthiness, so he can't pick on a third party and say, you do the inquiries on my behalf, that will satisfy it. In terms of a charterer's obligation to exercise due diligence in choosing a service provider, he probably can delegate, provided it's reputable, provided he's picking quality. I would say, arguably, that's a delegable obligation. So a charterer, in engaging with a quality service provider, can probably get away with exercising due diligence through undertaking that exercise. The Intertanko Express indemnity, and I've never seen this used in a charter party. I haven't had one presented where there's been a dispute. Now, it may be that it's used commonly, but I've never seen one thrown at me because it's never gone wrong, is a wide-ranging liability. Losses or costs arising out of or related to such operations. I would encourage every ship owner I know to use the Intertanko clause. Two ships collide, his ship is negligent. I would be pointing at this clause and just saying, well, all bets off. You know, you've indemnified me for it regardless of what I do. And I think you're in with the scope of arguing that. I'm going off to Greece next week to try and mediate in a high court dispute. So I can tell you the names of the parties and I can tell you the service provider as well. It was two ships. It was a ship called the Amantha, which had run aground coming out of Escravos, and a ship called the Sea Power, which was engaged by the charterer to lighter her. Fendercare were engaged as the providing the fenders, and the two ships came together. The weather turned bad all of a sudden, and during the pulling apart, there was damage suffered by the Amantha. A small amount to the Sea Power, but just around the back end of the ship there was some steelwork damaged, and we face a fairly substantial claim from the owners of the Amantha as the charterer as a result of it. In order to undertake the ship-to-ship transfer operation, we had provided a letter of indemnity broadly along the terms of the intertanko clause. Now, there is a large element which I would say was the Amantha's fault. She was bouncing around at anchor, she was uncontrolled, there were issues around that. She wasn't supposed to be, she was supposed to be hard aground. And the sea power did everything properly, but damage arose. The owners of the Amantha are pointing to that letter of indemnity and just saying, it doesn't matter, you agreed to indemnify us for everything, just pay. So that's the sort of thing where you need to plan ahead and think things through as to, are you giving a complete wide-ranging blanket indemnity, as you do under Intertanko, or do you actually mean it's got to be a little bit more restricted? And if you want more restricted, you need to say so. And it's no good trying to do it afterwards. Because afterwards, even if the parties had actually intended one thing, once their lawyers look at it, their intentions unbelievably and very surprisingly always change. So damage to vessels. Collision regulations, as I've said, I don't think they apply. I think it's a nonsensical argument to try and bring collision regulations into a situation where you're bringing ships together deliberately. So you're looking at negligence between the two vessels. Now that's the negligence of the two masters of the vessels, not the person, the POAC, not the person in overall charge, the two masters in navigating their vessels together and the cause between them. If there is an indemnity in the charter party, that's peripheral and would allow one party or the other to point to their charterer and say, you indemnify me. Inadequacy of fendering arises. I've seen complaints about fendering in the Sea Power and the Amantha case. One of the complaints was that the ship didn't have some additional fenders located in order to assist them breaking apart. Quite simply, nobody had thought of it at the time. It was, you know, it's the benefit of hindsight that these things crop up. The most common thing which I see are cargo issues. And at the end of the day, we do transshipment operations and we move cargo around the world in order to sell oil. And the shipping bit of it and the lightering operations and everything else is just really an inconvenient element in the middle because we can't build pipelines that are long enough and avoid using ships. So, cargo measurement. The ships are invariably moving around in the seaway and cargo measurement is always difficult. You invariably get differences between vessels. And what should go into the bill of lading? The bill of lading forms a contract between the ship that issues the bill of lading and the cargo owner and allows claims to be brought against that ship directly. So issuing a bill of lading that's inaccurate almost guarantees cargo claims. So accuracy in terms of cargo quantity and description of the goods. Quite often I've seen ship-to-ship transfer operations which involve cargo commingling or blending operations on board, and how you then describe that cargo and giving an accurate description to it is important. I also see owners panicking inordinately about it, rather than just saying, this is the bill of lading which we are prepared to issue, which is accurate for our point of view, and if you, the charterer, want anything else, do it yourself. Issue a charterer's bill, or issue a bill of lading yourself, and I will have a right of indemnity against you if you bind me into that contract. Ship owners panic. They always, the charterers put them under huge pressure, understandably, and ship owners quite often buckle to that pressure and expose themselves and potentially their P&I clubs and insurers to cargo claims. They need to take a firm line on that. The final one, and this is just because it cropped up the other day when I was doing it, water. Huge amounts of water on board. Ship finishes ship-to-ship transfer, master dips the tanks, finds out he's got around 1,000 tonnes of water in addition to the crude oil that is loaded. A disproportionate amount. What does he do about it? Charterer is insisting that he issues a bill of lading for the full volume of liquid loaded. Master's saying, well, I can issue it for the oil, but I want to highlight there's a large quantity of water and more's likely to drop out. A letter of protest won't help the ship owner in that case, and a letter of indemnity from the charterer is of no value whatsoever because it's unenforceable. So, that was a really quick canter through. I'm sort of thinking we've got vaguely back on time. If anybody has any questions, I'm happy to take them now, or I can fire away at the end. Sorry.
Really appreciate what you're saying, and quite interesting, but the discussion today was setting minimum requirements for STS providers for auditing us. Are we saying in what aspect of due diligence is not covered by OCMF service provider self-assessment in terms of this? You asked for a due diligence process, which we all adhere to.
Mm-hmm.
But which aspect of the existing service provider self-assessment due diligence process is not covered for this process that you're talking about?
I think I don't think there is an element that isn't covered, but from a ship owner's perspective, the ship owner has to make an assessment of what is being presented to him in order to undertake the ship-to-ship transfer operation. So the charterer will say, we want you to undertake a ship-to-ship transfer operation at this location using this vessel and this service provider. Are you comfortable with that? And what the charterer is trying to do is pass the responsibility to the ship owner. So the ship owner is presented with the information of service provider and the vessel that is undertaking the ship-to-ship transfer operation, which is going to be presented alongside his ship, and the location, and all of the other information. He has to make that assessment as to whether or not he is comfortable doing that, because potentially, if he says yes, particularly under Shell Voy or BP Voy, if he says yes, I'm comfortable with that, and as an aside, interestingly, Shell Voy doesn't include a warranty from the charterer that the other vessel will comply with OCIMF, with the transshipment. BP Voy does. BP Voy requires gives a warranty from the charterer that there will be compliance. So under Shell Voy, a charterer presents a ship. The owner is entitled to assess whether or not he thinks that is safe for his vessel to undertake the transshipment with. Now that's service provider and ship. Now,
I'm sorry, there's two separate things you're talking about here. You're talking about a ship which has got nothing to do with the service provider. So they've got to assess the two ships' compatibility between them. And then once they've actually assessed the ship's compatibility between them, they then approach us as service providers, who then assess the suitability of the two ships for ship-to-ship transfer.
Yes.
This is a technical process, not a paperwork.
Yes.
And then there is a joint plan of operations put together. There is a technical plan that includes risk assessments, it includes vendor selection, it includes POAC. All these elements are technical elements that are put together. That has to be presented by law for ship-to-ship transfer with oil cargoes to the master for assessment. How does the due diligence process you're talking about really affect the STS when we're actually doing the technical discussion with people who actually know what they're talking about?
It affects the STS, it only affects it when something goes wrong. And the lawyers then look at what was done by the various parties with hindsight in order to assess who is liable and who is going to pay for the damage suffered by one or both vessels or a pollution incident or whatever. So having, as I've said, having quality parties who have undertaken these technical assessments and being able to document it and justify it and explain what they've done protects the various parties as between their potential liabilities.
But if you look at the due diligence process that we seem to be exposed to, one is the mooring master tick box safety, where there's no checks done to make sure they actually have the minimum qualifications. It's just a tick box to say yes. Will that improve safety? Does that protect the ship owner in that there's somebody's tick to say yes, the mooring master is qualified? Is that protection for the ship owner?
In what sense?
example,
are you talking in the context of a port where you go?
No, we're talking about ship-to-ship transfer, the due diligence process,
right,
where we get emails asking us to give details of the POAC.
Mm-hmm.
Is he qualified with this? Is he qualified with that? Tick box.
Yeah.
Right? Does that protect the owner?
No, I wouldn't say so.
It doesn't, in any way. If they ask us for have you provided a JPO, have you provided a risk assessment, we go yes, 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 yes. Does that protect the owner?
If the owner's asking, I mean the owner's...
No,
sorry.
I'm only asking if that tick box question, say, have you done this? Tick, 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 tick. Does that protect the owner?
I wouldn't say so.
Correct.
When you submit your CMA,
it is protect the owner.
But the responsibility is the charterer who has to exercise due diligence in terms of providing these elements to the ship owner.
But we're talking about a due diligence process here that is tick box.
have you been ever in the United States? Have you applied visa for the United States?
Excuse me, I'm not talking about the United States,
No,
I'm
no,
talking
no,
about
no,
ship-to-ship
I will
transfer.
give you an
The
example.
due diligence process that actually has been
Yes,
followed
I
here,
will
which
give-
is a tick box due diligence process that we get online.
I will,
Tick, tick,
I will
tick,
give
tick,
you an
tick.
example. If you apply for a visa for the United States, you will be asked, are you a communist? Are you a drug dealer? Are you Muslim terrorist? Tick, 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 tick.
I think the point is,
This is due diligence.
these things land on my desk typically after something's gone wrong.
Yes.
So, but
And-
the question is very clear. Will a tick box assessment protect the owner in any way?
Yes. Yes.
Well, potentially, I don't know. I mean, you look at it, it depends on how it is completed.
A tick box, does he have?
Well, if it's completed correctly, and he does have, and it's
But what
said
if he
yes,
doesn't? It's a tick box. We have situations where we're getting assessments back from POACs with the wrong name, with the wrong, some of them I believe are even operators. So we've got completely the wrong information coming back to us on the basis of a tick box. People put any name down. There's operators, all sorts of people do all sorts of things there.
so
Is
if
that
the information
protected?
exchange is incorrect,
Can I ask you something?
Yeah, sure.
When we get the feedback from the master, and the master doesn't know who is the POG, because the master provides the name of the POG, is this a mistake of the master? Because what the database has, the names of the POG, the names that exist in the database, the data, are provided from the master.
Correct.
So if the master says that the POG is Alex Glikas, is this a fault of the master? Or is this a fault that there is no documented procedure delivered on board the vessel saying that the POG will be Captain Alpha Beta Gamma Delta?
So what additional checks are you doing then to make sure the information that goes out is correct? That's
We
the
inform you after we receive the assessment. After we receive the assessment, we inform the organizations related that we receive this
So that
information.
information is already provided to the charterer. So besides that point, I mean, this is something which we face. The question here is, which I would like to re-emphasize is, I mean, thank you for that, Steve. I mean, that was mostly to do with cargo stuff, which I understand. We're talking about due diligence, and Bob rightly said, that is just a tick box exercise. There is a pre-process which is also carried out in terms of risk assessments, various checklists, location checklists, that's already been done, okay? Number one. Number two, this additional due diligence, which is being talked about, is just a tick box exercise. So how does it prevent or provide additional benefit to the charter? Nothing. We need to really consider that. And second thing is, who is actually doing that due diligence? In the presentation by Captain from TMS, The top number 4 was STS knowledge. Now this is the key. STS knowledge. Who is actually doing that due diligence? With due respect to everyone here who does it, we need to be very careful. There's not a problem of getting assessed by someone outside. It's being done day in and out. All the oil companies, they don't do it. They are lacking resources, as Captain Ibn said. So they are welcome. Anybody comes and does the assessment, no problem. Who is actually, is it technically capable of doing it? That's number one, very important point to look at. If I go and audit and assess, I need to be able to understand how the compatibility has been carried out, how the mooring plan has been put together, and how the ships are going to come together, right? And this is basically being provided by OCMF. The due diligence has been done in place. So the additional benefit by introducing this additional layer is something we need to consider why it is being propagated. And secondly, if the party that comes and assesses uses that information, excuse me.
Why do you think it is propagated?
So, no, I'm just putting my point, so that the party that is doing that assessment uses that information to build a database that is being used as a commercial product, that is again a conflict of interest. So we need to consider all these things in a bigger perspective. I understand the due diligence part of it, we all agree with it, we accept it, but it has to be carried out by the right people in the right platform.
At last we agree on something. We agree exactly. This is what we said in the beginning.
The issue that we have faced from many tanker operators, I don't want to say few many, is that when cargo owners are dealing with approved service providers, for example, like Fendercare. So eventually, a POC is nominated by Fendercare to do the STS operation. Is there any reassurance provided by the cargo owner to the tanker operator that this POC has been assessed according to what Bob mentioned before? Is there any reassurance for the charterer provided to the tanker owner apart from the fact that, as you very well mentioned in the emails we received, that you are audited by many service providers, etc., etc. Why are you audited by many service providers and not many charterers and not by one? Because each one wants to assess you with his own criteria, which are never announced to the tanker owners.
Well, that is fine. We are not arguing about that criteria. Anyone can have his own criteria. Exxon have got their own criteria, BP's got their own criteria, Repsol, as we understand, that is perfectly all right. What we are trying to understand is what are we actually gaining by this additional due diligence, which we say is just another tick box exercise. You know, I mean, we need to understand that.
Can you provide an alternative in order for the tanker owner to do a due diligence very shortly, within 2 hours, 3 hours?
Yes, we do that.
100% of our operations, we do that due diligence, and we put it free to the tanker owners. It goes via the master. The master is totally entitled to ask for 100% of that information. It's sent on board before we arrive with all the certification. The master's go on board, they can present the certificate.
Are you representing all service providers around the world or STS? Because the procedure you say it's correct, but tanker operators does not know if this procedure is fulfilled.
I'm sorry, but if the tanker operator doesn't know it, the tanker operator doesn't have a management system, because every competent tanker operator has an STS plan that's approved by class. Within that plan, the process by which the ship-to-ship transfer is going to be done is documented. Within there are certain criteria that have to be met before the master is allowed to do that ship-to-ship transfer operation. Are you actually saying if the master is not competent to ask for that?
No, I say that the master does not know who is the person who plays the role of POAC. He has to ask if this person is competent.
The POAC is a tiny, tiny piece of the jigsaw.
One example, yes. Are the vendors? I totally agree that the right procedure is the one we described. But is this procedure followed by all service providers around the world?
No, sorry. Is this procedure followed by every tanker operator? What you should be telling is your tanker operator, sorry guys, your procedure should be this. This is what you should have in your STS plan. tell your masters to follow this and you'll be 100%.
There is an issue with this procedure. We have faced this issue in the past, and the issue is that sometimes the service providers do not provide certificates for fenders hoses. They don't have what you expect to deliver, and you expect to do an STS operation. So it's too late.
Just say no.
Why would you use those providers?
As a charterer, are you expected to receive a letter of protest from an owner in case a service provider does not meet the OCMF criteria?
May I give one example where the tick box thing goes horribly wrong? We were asked to intervene on an operation in the ARA region quite recently. We were told that it was a reputable service provider, and we were told that basically the operation would go ahead, and we said, well, hang on a second, we're not quite happy with this. Can we do some digging, please? We did some digging. The situation was that not only was the equipment completely under spec for the job, when we actually researched and asked for the box to be ticked on the provision of certificates for the equipment, we proved scientifically they were actually falsified. Now, if we had not done our due diligence level, as an STS service provider, we put a man in over and above the appointed service provider to do the job, to make sure it complied with port regulations, and we took it benchmarked to MARPOL level. Had we not done that, they would have gone ahead and used not only fenders which were at the time not certified correctly and completely undersized. It was actually fenders for a 10,000 ton tanker with a 100,000 ton tanker. It wasn't just a minor slip. Had we filled in the tick box and not done the digging and the correct work, that operation would have presented a massive risk to both vessels and the port. That's a danger of a tick box. We do the digging underneath, we do the work.
Yeah. Who said that the due diligence is just a tick box? Nobody said that.
It's a questionnaire. It's a tick box questionnaire.
May I ask Stelios to come up? I mean, I'm conscious of time, but Stelios, do you want to carry on with your presentation, and then I'm sure we will get lots of questions around audit and ticking boxes.
While you're standing up, I'll make one little more point while I have the opportunity. When we have the audits, it's an office audit, 2 days minimum. It's a base audit, 1 day minimum. It's an operational audit, normally 3 to 4 days. How on earth can you replicate that through a tick box? You cannot. And we must have a master mariner that goes and does the offshore operation, and we need somebody who knows the equipment in depth that we work with to go out and do the base audit. It doesn't come from a form, it comes from people who have the experience in the industry who know how to do it correctly.